Hello, everyone. Good morning or good afternoon. Thank you for attending today's webinar, The Value of Cyber and Privacy Diligence. Before we begin, we have a few housekeeping items to cover. If you have any questions during the webinar, you can submit them through the Q&A widget at the bottom of the screen. We'll try and answer some questions during the webcast, most likely at the end. But if there's a more complete answer needed or we've run out of time, we'll answer later by email. A copy of the slide deck is available in the resources widget, and we encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical questions located in the help widget at the bottom of the screen. Today's training is CLE accredited in Illinois and California and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, and in New York for 1 hour of general cybersecurity, privacy, and data protection credit for experienced and transitional attorneys. We award CLE credits based on attendance for the entire 60 minutes. And so due to some changes in jurisdictional requirements, we're no longer able to use automated pop-up attendance checks. So as we're required to, we will display some secret words in 2 multiple choice polls during the presentation. You'll be required to select today's secret word that I give orally from a multiple choice list. Please respond to the 2 polls to demonstrate your continued engagement and to earn your full CLE credit. We value your opinions and appreciate your participation in today's course. So with that, again, welcome. Thank you for joining us today as we discuss the value of doing good diligence on privacy and cybersecurity topics when you're doing corporate deals. I'm Jim Shreve, and I chair the cybersecurity practice here at Thompson Coburn. And leading the webinar today, I've been doing privacy and cybersecurity work for almost 25 years now. I've worked on a lot of deals. I've seen a lot of them go great. I've seen some of them go poorly. And so I'm going to hopefully give some insights to promote more of the great deals and fewer of the poor ones. So with that, could I hand it off to my fellow presenter, Matt Darrough, to introduce himself.
Yeah, hello, everyone. Matt Darrough. I chair the insurance practice group here at Thompson Coburn. I've been doing insurance practice for a couple decades, and I'm within the business litigation. I do other types of litigation, but the focus is on insurance. Matt Hafter.
Thanks, Jim. Hello, everyone. My name is Matt Hafter. I'm a partner in the Chicago office. I lead the technology transactions practice group here at the firm, which is part of I am part of the mergers and acquisitions, corporate and securities practice group. I've been doing this for 3 decades now.
Emily?
I'll just take a minute here and welcome everyone. Thank you for joining us today. I'm a partner in our corporate and securities group, resident in the DC office. M&A is my very favorite type of transaction and type of work. And I've been doing it for about 20 years with a focus on higher education. Look forward to discussing these issues with everyone.
All right, thanks everybody. So, what are we going to talk about today? So I'll lead off and give some of the things that we've seen in terms of new attacks, new requirements, and what are some of the new risks that we've seen out there, that militate towards doing more and better diligence on cyber and privacy issues. Then we're going to look into what is the value of that good diligence? What does it look like? What are some of the hallmarks of it? And so you can do it better. We'll talk a little about rep and warranty insurance, because this is a big topic that often comes up in the cyberspace, particularly to cover some of these risks. And then we'll have a bit of a roundtable discussion on some of the lessons learned in doing this for a while, and then give some of the tips we have for mitigating some of those risks you can avoid some of those headaches, and we'll take some of your questions that you can submit online as we're presenting. So, let's start off talk about what are some of these risks. So, cybersecurity is constantly changing. There are constantly new attack vectors that someone comes up with to hit companies, new ways to steal data, to misuse data. And so, what have we seen, say, over the past few years? The attacks have continued to increase over my entire career, but the nature of the threat always changes. Ransomware is still extremely popular. This is an interesting area because there was a change due to geopolitical issues when Russia engaged in military action in Ukraine. That engaged the two biggest sources of ransomware attacks on the globe. And so, whereas ransomware attacks had constantly been going up for several years, they went down, at least for a while. But now I can report they are coming back for a variety of reasons, including the fact that Russia is finding this is a good way to raise hard currency in an environment where it's hard for them to do in other ways. Business email compromise, it picked up some of the slack where ransomware attacks went down last year. Business email compromise attacks went up. So spoofing emails, emails that use manipulation to try and get people to send information, send money. We've seen more and more of those coming up in the last year, as well as attacks on executives. Going after some of the high-profile, high-value targets in a company when they're outside of the company's firewalls. That's definitely been on the rise of late. We've also seen kind of a movement of industries. When I started out in this field, I was working pretty much exclusively in financial services, and financial services were getting bombarded. It's not as though they're not getting bombarded, but there are a lot of large banks out there that have cybersecurity budgets that are bigger than some countries. So rather than going after that very secure target, they're moving to maybe smaller banks. They're moving to mortgage companies. They're moving to money transmitters. So less regulated entities, as well as moving into other industries. Healthcare has long time been a significant target, but as healthcare has gotten more secure, we've seen some of that go to other places where you can get maybe the healthcare data without going after the more secure hospital system that might have it. And so we saw attacks that more often were attacking governments, especially local governments, where they don't have the resources to protect the data as much, but they have a lot of very sensitive data on their systems. We also saw movement towards higher education. Higher education, unfortunately, can be one-stop shopping for information. You can get financial data, you can get healthcare data, you can get government contractor data all in one place. So there was definitely a movement towards attacks in higher education. And then since then, we've seen more attacks in the technology space. Go after the new startup tech companies that may have thought about how to build this great new idea, but not necessarily how to secure it. Go after manufacturing companies where you might think, oh, they don't have a lot of data, but they do have personal data, certainly on employees, and they have it on customers, but they may have a lot of IP that's very valuable and worth stealing or ransoming. So we've seen that the attack vectors certainly change for the last few years. As these attacks have been in the news, we've certainly seen legislators and regulators react to those attacks and threats to force companies to be more prepared and to protect customers and consumers. We've seen several new requirements recently on the cybersecurity side. The FTC in 2021 increased the requirements under the GLBA safeguards rule to have many more specific cybersecurity control requirements in place. The SEC has proposed rules for securities entities. They took a somewhat different tack than the FTC in that same space, but voluminous rules. They issued over 800 pages worth of rules on this earlier this year on the same day. So a lot of new requirements. We have new standards put out by the National Institutes of Standards and Technology, SP 800-171, which applies to government contractors. We're seeing revisions to that to ramp up those requirements, as well as the NIST cybersecurity framework. So looking at the new attacks and responding to those with a lot of more specific requirements. We're seeing some brand new standards. FERC recently introduced a new standard on supply chain risks in the bulk electric system. So that's another industry sector that's introducing brand new requirements on this. And then we have significant rulemakings that are coming under the Critical Infrastructure Act of 2022. It mandates rulemakings that are going to take several years to put into place for several different industry sectors that are deemed critical infrastructure. And so a lot of that goes to the Department of Homeland Security, but there's also carve-outs for certain otherwise regulated entities like in financial services and healthcare and energy as well. I'd say the overall trend is towards having more specific, more prescriptive requirements on cyber. So rather than just saying do a risk analysis and put something into place that meets that risk, now you have to do that risk analysis and put the controls in place, but they have to include at least these things. So that's definitely something we've seen lately. On the privacy side, we've seen a number of new requirements as well. The action here really is at the state level. There's a perception that not enough is getting done on this in DC. And so we've seen California, traditionally a leader on privacy issues, introduce and enact this broad-based privacy law, the CCPA, the Consumer Privacy Act, later amended by ballot initiative, the Privacy Rights Act to further strengthen it. That's a broad-based privacy law, has a number of requirements privacy-wise that go to companies that do business in California and meet certain, often fairly low threshold requirements in terms of size or activity. It grants these rights to California residents. Several other states have followed suit. We have now, I think, by my last count, 7 other states have enacted a similar law. All of them differ a little bit from each other. They generally are based loosely on California, but some of them go in a little bit different direction. And I think we're going to see a lot of these kind of laws coming up in the next few years. As well as other things to watch for coming up. Children's privacy is a hot topic and a very popular one among legislators and regulators. So we've seen amendments to COPPA under the legislation, as well as the FTC's regulation of it. We've seen a new children's privacy law in Utah that is aimed at websites and online platforms that target children, collect information on children. Significant potential penalties under that law. And we're seeing a lot of global requirements. Everybody knows about the EU's GDPR, but we're seeing a lot of other countries enact requirements. Canada is considering significant changes that would ramp up their privacy requirements under PIPEDA. India is considering a significant broadening and deepening of their national privacy law there. And most of these are based somewhat on GDPR, but some of them are a little different. Some of them even go farther than GDPR. And that's a trend I expect to continue in the next few years. So I'd say one of the biggest changes lately is in the increase in litigation risks. Privacy, cybersecurity both used to be more about compliance exercises, honestly. But now I think there's a real risk of significant liability, and whether it comes from regulatory enforcement or an action by a state AG or by private litigation. And the first of these laws I would highlight is BIPA, the Biometric Information Privacy Act here in Illinois. This is a statute that's been on the books for quite a while, but it's only really been a source of litigation in the last few years, and we've had some significant court rulings that broaden the scope of BIPA and significantly change the liability. Just in a nutshell, I mean, we've done several webinars on BIPA, and so I urge you to go on our website, look at in further depth about BIPA. But it's a law that says with biometric information, you have to get affirmative prior written consent before collecting the information. And then there are also requirements about how it's stored and used. It has a private right of action for impacted individuals. The Illinois State Supreme Court has said that there's no actual harm required to be an aggrieved person and bring an action under BIPA. There's statutory damages of $1,000 for most violations, $5,000 for willful or intentional violations. And recently, the Illinois Supreme Court has said that each collection of a biometric is a separate claim, so that it greatly increases the potential statute of limitation period, and it greatly increases the potential liability. And so we're looking at judgments that could be in the tens or hundreds of millions of dollars under BIPA. So that's significant liability risk. State AGs are often also looking at taking more actions. We've seen some of them already doing so. It's an attractive avenue for an elected AG to be seen as protecting the privacy of state residents. And so we've seen some of them take actions under biometric privacy laws like in Texas, or under the general privacy laws like we've seen in California. Federal agencies, several of them can use sort of their specific authority, under a privacy law, or more general authority like under Section 5 of the FTC Act to pursue privacy claims or cybersecurity claims. I would particularly point out the FTC. It's very, very active right now. They are led by a director that wants to be aggressive on these enforcement actions. And so both on the privacy side and the cybersecurity side, they've said explicitly they're going to go after people for failure to meet the requirements. So on the cyber side, there's still fewer private rights of action on the cyber side. But one thing that has happened recently is when the California enacted the CCPA, the privacy law, one of the provisions there was to make it easier to pursue security breach actions by private litigants. And so we've seen an uptick in that kind of activity. And so whereas security breach lawsuits typically have not gone anywhere, this does create the possibility that they could, and you could have very large class actions under those. Also, deceptive claims, we've seen an uptick here. We've seen a real push to use the False Claims Act to go after government contractors that misstate their cybersecurity compliance and preparedness. And this can be difficult because these requirements, you're signing off on oftentimes hundreds of control requirements when you sign off on it. So just missing one or two could open you to potential liability, as well as use of UDAP, unfair, deceptive acts and practices laws, to go after misstatements about cybersecurity preparedness. So you had a security incident, and you made very grand statements about your security preparedness in your privacy policy or other public-facing statements. This is a way that someone could go after you for that. Contractual liability. Contracts can go well beyond what the legal requirements are. So I would note where you're taking on some of that liability risk, or companies that you're acquiring have. And also for public companies, we've seen shareholder actions in the aftermath of security breaches, where a security incident has a significant hit on the reputational value of a company, and it affected the share price. We've seen shareholders potentially bring lawsuits there. So with that, I'm going to give the first of our two secret words. The first secret word is privacy. So on your screen, you have three multiple choices. Please pick privacy here to show that you're online and paying attention in order to get your CLE credit. So we'll give you a few seconds here to choose privacy before we come back and pass it to some of the other panelists to talk some more about the value of doing good diligence in privacy and cyber. So please select privacy from the list above. Looks like we've got most people in. I'll give you another 10 seconds here, and then we'll move along. So last chance. Please choose privacy. Okay, ready? Okay, let's move along. So all of this should make you think, what we're acquiring this new company. We don't necessarily know a lot about them, but you can see that what we're acquiring with all those assets is the potential for significant liability, either on the privacy side or on the security side. So we have some general thoughts about doing diligence and specific ones in the higher education and technology space. And so with that, I'll pass it off to Emily Murphy.
Great. Thanks so much, Jim. I thought that was an immensely helpful overview of the landscape. Really great picture of how it's really come into, with our online world these days, it's only become more and more relevant and really needs to be elevated to every company's priority list. So as he said, Matt Hafter and I are the corporate attorneys here. So we'll talk a little bit in general about corporate governance and hygiene, a little bit on the value of the diligence, and we can approach it from the seller perspective. How do you get ready for a sale? We'll address it from the buyer perspective. I mean, what are you looking for? How do you manage your risk? And where are those big dollar items going to come from? So if you take a look at this slide here, so I do almost all M&A in a variety of industries and maybe half my time in the higher ed space. I can definitively say it's not a matter of if, but when. So everyone is really being targeted because it's an easy way to get some quick money for the bad guys out there. And, we'll talk a little bit about which industries are being targeted. Some are more focused than others in terms of the scammers' attention. Naturally, if you think about it, the, really sophisticated IT media companies are more difficult to infiltrate. So they're not on the high level target list, but there are some other industries, including higher ed, that can be considered more vulnerable to these attacks. So why is this important? Obviously, a breach of personally identifiable information is embarrassing. It's a PR issue. Then you've got lawsuits. You've got government enforcement. You could have, complaints from customers and students and staff. So just generally speaking, it's just very disruptive to your business for this to happen. Even non-private data can be very disruptive. And you'll see just a number of things that I've seen in the higher ed and outside of higher ed. Lost revenue, you've got this ransom demand. How much do you need that information that's been locked up from you? This means that your management is distracted from their business goals as they deal with this crisis. I've seen businesses take time to recreate their data. I had a client, multi-$100 million client, who lost all of their orders. So they had absolutely no idea who had ordered what from them, and they had to go back and recreate all of this data, obviously threw them off track from their goals for that quarter. And even putting all of that aside, you're looking at legal costs, crisis communications, all of these expenses that will come up if you are subject to a breach. So let's see, a couple of things that we'll go through, being proactive. investing in technology and experts to protect your company and your business, and reducing the likelihood of being at the top of that target list for hackers and scammers. And so I'll just take a few minutes to focus on the issues in higher education. You'll see that first bullet says 79% of post-secondary institutions reported attacks in a recent report. And so that puts higher education as the unenviable position of first place for most targeted industry last year. And that continues to increase year over year. It was in the 60s, now we're at 79%. As Jim mentioned earlier, there's a lot of valuable data, one-stop shopping at your university or college, social security numbers, financial information, bank accounts to pay tuition, dates of birth, student data. So it's just a wealth of information for people to try to steal and lock up. So how are they infiltrating? I think the number one reason that higher ed is being targeted is because of the system vulnerabilities. Higher education tends to have some more outdated and older business systems. Sometimes it is not a priority for the boards to spend that money on cybersecurity and sort of that proactive protection of assets. Sometimes they're more focused on research and development, and they just have different priorities. You'll see here a second issue is that you've got students, faculty, and researchers who are abroad. So now you have this worldwide business system, and it's more susceptible to hacking if people are coming in internationally, just generally to use your system. And, of course, the credentials and passwords, people sometimes don't put the best passwords into place or don't update them. So, and a couple of other things to consider, obviously during the pandemic, a huge increase in online education, right? So everybody had to pivot to Zoom, everybody had to put their systems online. And then again, sometimes it's not a priority for higher education institutions to prioritize the protection of that very valuable asset of online education. And then, of course, scammers want the lowest hanging fruit. What is easiest, right? So you've got universities who may have vulnerable systems and huge endowments or, huge pots of money. I mean, it's just a no-brainer why education is number one on the list of industries being targeted. All right, so on this slide, I'm going to talk a little bit just about what I said earlier, just having some general good corporate hygiene, right? Just taking the time to invest in technology and business systems. Unfortunately, it is not a priority of many boards of higher ed institutions, but it's really critical, particularly for, ed tech companies and, most universities now have online programs. So you're very vulnerable to attack if you don't put things into place like two-factor authentication. Those are just really table stakes here in 2023. And Matt Darrough will speak a little bit about insurance. I don't think it's a cure-all, but it's certainly a good thing to look at your policies, speak with your broker about having adequate and appropriate coverage, depending on how much of your education systems are online. So really, those are just some, basic steps that you can take to prevent, any sort of lawsuit, whether it's from the feds. And I should have mentioned this earlier, but in addition to all of the federal agencies Jim mentioned earlier, there is a law called FERPA, which is the Family Education, Privacy Act. And so that is enforced by the Department of Ed. So really, anytime you have the feds on your back, it's really not a good look. So, you really want to insulate yourself from, private lawsuits, government investigations and ransom demands. So with that, I'll turn it over to Matt Hafter to cover the second half of this slide.
Thanks, Emily. I think all of what you said is an excellent overview. And in particular, you pointed out some key elements of vulnerability for the higher ed space, and really that can be transposed to pretty much any other industry, especially the challenges of budget allocations, having far-flung operations and personnel, and having outdated or antiquated IT infrastructure. So those are all really critical points to keep in mind across the board for all industries. I'm going to focus next on adding to the good corporate hygiene concept and dive a little bit deeper into other value-enhancing steps that an organization can take to help protect itself and thereby help increase its value in the context of a potential acquisition. And then by the same token, all of this applies on the other side. If you're a buyer, you'll be wanting to consider these items as part of the due diligence and part of evaluating the price for the target company. So the first issue to address is the differences between a software license and a software as a service platform. The software license typically contemplates that the user, the licensee in this case, will actually load the software code onto the user's own computers. And this creates a unique risk because third-party code is actually within the user's own IT environment. And therefore, it's critically important that that software be scanned for viruses and subjected to penetration testing to make sure that it's secure. It's also important that the licensor of the software provide appropriate representations and warranties about its code and about the cybersecurity risks that go along with it. A SaaS arrangement is a little different in that it keeps the actual software within the confines of a third party, the SaaS provider, and it allows the user to access and use the software hosted by the provider and accessible through the internet. Because no actual software is provided to be used within the user's IT systems, this shifts the risk largely, but not entirely, from the user to the SaaS provider. And so this means that the lens needs to focus as well on the SaaS provider to make sure that the SaaS provider has taken appropriate steps to protect its own software platform from harmful code or data breach. And so this can be accomplished through a number of overlapping actions, and these apply really to both SaaS platforms and software licenses. First, the licensee or the SaaS user can do some initial due diligence about the provider's experience with cyber events, the longevity of the platform, and the software in the marketplace, and what vulnerabilities have already been subjected to attacks. Next, the license or SaaS agreement should have representations and warranties from the provider or licensor to the effect that it has implemented up-to-date industry standard scanning tools and other security measures to assure that as much as possible harmful code has been detected. Over the last, say, 5 years or so, the trend has been that the licensor or SaaS provider will not provide a representation and warranty that there are no elements of harmful code, but simply that they have taken industry standard, commercially reasonable steps to investigate that and to try to prevent it, which shows you that the ubiquitousness of the risk here. Third, the agreement, whether it's a license or a SaaS agreement, could include and should include covenants that the provider comply with ongoing security procedures to, at the very least, comply with applicable law. Some of those that Emily and Jim mentioned, depending on the industry, become critically important. And more generally, that the licensor or provider, in this case, has implemented physical, technical, administrative, organizational safeguards to ensure securities. And so, for example, these could include defining exactly what a security breach is, so that it's broadly defined to include both an actual breach or pings to attempt a breach or even complaints about potential breaches. The contractual provisions could also require that the SaaS provider would meet a particular standard of care that complies with one of the various accepted rubrics. The NIST framework that Jim mentioned earlier is one of the common ones. And then a whole host of physical safeguards, technical safeguards, such as firewalls, badged access to critical sites and things of that nature. And then finally, obtaining outside audits of security procedures through SOC reports. And that's a very hot topic and a somewhat complicated topic, depending on which particular kind of SOC report is to be provided. But at least that enables the user to have some comfort that an outside reputable party has gone through the exercise of taking a look at it. Next is always the possibility of cyber insurance. And especially in the case of a SaaS platform, you're going to want to consider the cyber insurance that your organization has and also that the SaaS provider has. And it may be worth digging down a little bit to see policy limits, of course, but also the scope of protection that it offers. There are obviously various degrees of protection that a cyber policy can offer, and it's important to know what that is on both sides of the transaction so that you can assess whether between the two sides the policies provide a level of comfort that will allow the deal to continue. Indemnity is a very tough issue, although we see it in all kinds of other supplier type arrangements. It's really hard, I would say impossible, to get the licensor or SaaS provider to indemnify for cyber risk, given the potentially massive liability risk that comes along with it. And that's when you start thinking about your and the provider's cyber insurance as a backstop to that. The next question, the next contractual issue to think about is liability caps for cyber events. And typically a contract will have both an exclusion of consequential and incidental and a whole laundry list of other types of damages other than direct damages. And it'll also have a dollar cap on the amount of the dollar amount of liability that the provider could be liable for. Typically, we see some number of months of service fees, 12 months, for example, of service fees. Well, for the operation of the platform itself, that might be sufficient, but the cyber risks are obviously much bigger and much more significant. And so we will often see a discussion on that issue where the user wants no liability cap and no exclusions for cyber events. The provider obviously is on the other side of that debate, and so sometimes there's a compromise where there's a super cap for cyber events and also possibly a definition of what actually would be included in, quote, direct damages as opposed to consequential damages, and that direct damages would explicitly include, for example, notification, credit reporting, costs of working with government bodies, and so forth. And then the last item to think about here as a value-enhancing step is code or SaaS platform escrow. This is a really controversial area, particularly as it relates to the SaaS platform escrow. But basically, the idea is that the licensor or SaaS provider deposits It's source code, flowcharts, build instructions, programming terms, third-party dependencies, and things of that nature with a third-party escrow agent. And if there is a bankruptcy or a failure to provide the platform or going out of business or something, some catastrophic event like that, the user can then, or licensee, can then make a request of the escrow agent to release the deposited materials, and then the user can stand up a new SaaS platform or continue to use the source code and the programming after the provider or licensor has disappeared from the scene. In terms of M&A, and I know Emily's going to have a lot to say about this as well, but every step towards mitigating cyber risk is going to be a value add, both for the buyer and the seller. Particularly, for example, if your buyer is a public company, that public company is going to have its own stringent requirements and concerns about cyber risks. But even a private equity buyer or a strategic buyer is going to be concerned about that and will be glad to see that cyber risks have been mitigated. Among the issues or among the steps that we recommend are doing a pre-diligence so that before the formal due diligence process starts, documents and have been gathered and questions have been addressed about this. It's good to ask both from a buyer and seller perspective, what is mission critical, what actually drives the value for this business, and then focus the diligence efforts on those assets and asking how well protected those assets are, whether they're used internally as a software license or outsourced through a SaaS arrangements. In the M&A context, the reps and warranties that we see most often are, number one, does the organization comply with all the applicable laws and regulations regarding the collection, storage, use, disclosure, and so forth of personal information or other protected information? Second one we often see is, does the organization have a privacy or data security policy? And appallingly or shockingly, a lot of organizations, a lot of sellers don't have that. But assuming there is one, the next question is, does the organization actually comply with those policies? And there's often a gap between the policy and the actual practice. And then the fourth rep and warranty that we usually see is a request to describe incidences of data breach in recent years or recent government inquiries or government enforcement actions. So those are some steps to be thinking about in advance of a transaction, both as a buyer diligence, from a buyer diligence perspective and from a seller value enhancement perspective. And with that, I'll turn it over to, I believe, Matt Darrough.
Thanks, Matt. And I'm going to focus in a second on representation and warranty insurance, but both Emily and Matt mentioned in the good hygiene cyber risk policies. So because it is not a question of if, but when, and as we heard, attacks on pretty much every type of industry and all sizes of business, it is important to maintain, to the extent possible, a cyber risk policy. They provide a number of first-party insurance, types of first-party insurance, and by that I mean it would pay to satisfy the losses that the company would experience because of an attack, whether it's the forensic investigative cost to determine and remove the perpetrators from the system, PR costs, the notice costs, if that's required to send to people whose information was accessed, or ransomware and other types of first-party costs. And it can be designed to pay provide liability coverage as well if there are claim suits from whether they be from the government or from private individuals relating to a breach situation. With respect to representation and warranty insurance, it's grown very popular and it is increasing in popularity. It's usually purchased on the buyer side. It's an effective tool in handling the risk associated with a breach of the seller's representations and warranties in the transaction agreement. And the way it works is the insurer steps in to satisfy the damages resulting from that breach. It eliminates or at least minimizes the need to set aside significant monies in an escrow to ensure funds are available to satisfy that breach. Typically, they are written such that the insurer won't pursue through its subrogation rights claims against this seller for the amounts it pays out. There's always an exception to that for a breach resulting from the seller's fraud, but they are usually written that way. They are not, however, written on a standard form. Each insurer has its own form policy, but it's a competitive market now, and as such, most of the forms work in a similar manner and provide similar coverages. That doesn't mean they don't have to be reviewed, and they can be negotiated, and the devil's obviously in the details of the forms. The representations usually in the deal documents concerning cyber issues and risk. Sometimes the fundamental representations just pertain to compliance with applicable law, and so it could pick up some of that. But as Matt mentioned, there's increased focus on cyber and M&A deals, and sometimes there's cyber-specific representations, including, past security incidents or the adequacy of internal controls, compliance with particular privacy laws. The underwriting process for this type of policy is involved. It's not such that you just submit an application and the underwriter looks over it and approves it and says, we've got you. They scrutinize the transaction that's being contemplated. The underwriters might want access to some due diligence materials or due diligence memoranda to understand what the risk that they're being asked to insure. And while there are some exclusions written into the forms that are pretty standard, there'll be a placeholder there for the underwriter to add some deal-specific exclusions if, when they're involved in this process, they feel uncomfortable because there's an unusual or extremely high risk. They might add a deal-specific exclusion to carve that risk out. Most of the forms do not presently include an exclusion that broadly removes coverage for cyber risk, but they can be written in through these deal-specific exclusions. And the underwriters are increasingly concerned with the cyber exposures, as everyone is, because of the frequency and severity of the events that are increasing. So they're going to want to be comfortable with that risk. They're going to want to know the buyer has performed the due diligence on the target's cyber exposure. They might be looking at the history, the target's history of cyber events, the infrastructure of the target system, the quantity and nature of the target's stored data, the adequacy of the target's policies, procedures, security controls, indemnification language, and vendor agreements, and the target's existing cyber risk insurance coverage and how that is set up. So really, in conclusion, you can't assume that the rep and warranty insurer is just going to pick up automatically the risk. It really depends on the situation. It's an effective tool in transactions, but it's not without limitations. And like the buyer, the insurer is going to want to appreciate the risks that are involved with the target company And if that risk is extreme or unusual, the underwriter could very well insist that any deficiencies be addressed before the transaction closes, or otherwise they might just try to carve it out. But get involved with a good broker if you're interested in purchasing rep and warranty insurance for use in a transaction, and an attorney to help you navigate these forms and work through a solution and negotiate it with the carrier so that it best serves your purposes. With that, I'll turn it back over to Jim.
All right. Thank you, Matt. So time for the second secret word of the presentation. The second secret word is litigation. Please choose litigation from the multiple choice answers on your screen, and we'll move ahead here. So please select litigation. And so we're going to move into the final portion of the presentation here in just a moment, where we're going to, all the panelists can offer some of their lessons learned, some insights from what they've seen in M&A and some of the privacy and cybersecurity issues that come up, and then a few tips for how to maybe mitigate those. So please choose litigation from the choices on your screen, and we'll about 10 seconds. We'll move on and finish up here. So choose litigation. Okay, let's move on. So yeah, we've been through a number of these deals, obviously, and we've seen a lot of things. And I think all of us have some thoughts here. I'll lead it off quickly, and I'll pass it off to others. But one of the things I would note on this is in regards to startups and to some extent some of the lesser regulated industry companies. Startups sometimes can regard any type of compliance as overhead, and overhead is to be avoided. On the other hand, most startups want to be acquired. They want to be bought by someone. That's the ultimate end goal. Less regulated industries can think, oh, we're not a target. We're a manufacturer. We don't have a lot of data that somebody would want. But you do, and particularly nation states may want that IP that you have. They may want to use you to get to someone else you do business with. And I would note that the diligence process is quickly maturing. I mean, it's possible that if you're a startup, you may be acquired by a regulated company who has significant expectations on what you're going to have privacy or cyber-wise. If it's a VC firm or private equity firm, they're significantly ratcheting up their diligence in this space and bringing in a lot of people who are experts in this to do more than just kick the tires. And as Matt mentioned, the insurers themselves are increasingly stringent in this space, and they're asking a lot more questions about deals, wanting to know how much you've looked into things, what you've looked at for an acquirer to know what kind of liability you're acquiring. So pass it off to others. Emily, do you have thoughts in this space?
Yes, I do. I'd love to share, and Matt Hafter was right. I do have so many thoughts, so I'd like to share them in no particular order. Again, I like to approach diligence from the perspective of the seller and the buyer, so I'll just make a couple of comments. We all know what the cyber and data privacy reps are going to be in a transaction. So the question for the seller is, can you make those reps? We love when our clients come to us in advance of a transaction. Let's say we're thinking of selling next year. Can you help us get our house in order generally and on the cyber side as well? That is music to our ears. We love to update the privacy policies. We'd love to get everything, so that when it comes time for diligence, everything looks like it's in order. If you're an ed tech company, you're going to want to have absolutely perfect and sparkling compliance on the data privacy and cyber side. Like that SOC 2 compliance that Matt Hafter referenced earlier. I think of that as the good housekeeping seal. If you can hand that over, that means quite a bit to buyers and others who are looking at that target company. So On the buyer side, I think it is, kicking the tires. It's scrutinizing those disclosure schedules. It's conducting IT due diligence, which I've seen people outsource, bring in a Baker Tilly or somebody who's going to go through the wireframes and kick through the software and make sure that it does what it's supposed to do and that it's adequately protected. And to Matt Darrough's comment about the underwriter process, you will be facing an underwriter call, right, where the buyer and the seller are sort of, I think of them as on call for, have you done your homework? Have you guys protected the target company? And buyer, have you adequately diligenced this company in order for everyone to understand the risks that are involved? So it can be kind of that underwriter call I always think of as like a colonoscopy for the poor target company, but it's a good practice for everybody to get on the same page and know what those risks are.
Excellent, Emily. Thank you. So I think maybe let's kind of talk a little bit about tips here. So let's finish up here with a few of these. There are a few here on the screen. Some of them relate to some of the things Emily just talked about, and others had as well. Think about your diligence list, and I would urge you to update it. It can be updated based on changing requirements, changing trends. What you've seen out there in the marketplace, as well as your experience as you go through a deal and something doesn't go well. Maybe update things for the next one so you're better prepared for it. So you can constantly be kind of updating that. And then I would also urge you, don't treat the list too much as just check the box. You may need to be flexible. As you dig into a company, you look at them through the diligence process, you may learn things that take you in a different direction than you thought it was going to go. And so you may have to go into something new, something different. And so have some flexibility to be able to do that and really listen and think about the responses you're getting to those first questions. As well as I think it's great to tabletop this stuff. If you haven't been through an M&A process, let's say as a company, maybe you can simulate it. Think about, do a mock exercise of somebody who's acquiring us and what would they be looking at. You can do it in-house, or you can bring in somebody that can kind of test you and think about that stuff. It doesn't have to be a formal audit process. It can be much more informal than that if you haven't done any of this stuff to begin with. And so you can see some of the fundamental things you need to get into place before you go into a deal. And so others have any other tips that maybe want to share?
Yeah, Jim, it's Matt Hafter here. I would, in the category of outside resources, I would also consider looking to other industries as examples of where risks are and how they've been addressed both in the operational sense and in the M&A context. For example, there's an absolutely terrific resource that the Department of Health and Human Services put out recently called Hospital Cyber Resiliency Initiative Landscape Analysis. And in it, they identify 10 key observations based on their own empirical research. And then they have a compendium of description of threat actions, impacts, and then bullet points on potential mitigation. And so that resource by itself is very valuable, but also just looking beyond the educational context to adjacent types of businesses, I think could be helpful.
Yeah, that's great, Matt. Thank you. Any other thoughts here? We're coming close to the top of the hour.
Real quick, and I was just going to add that all these efforts to get your house in order and mitigate risk are something that benefits you when you go to place the cyber risk policy as well, because the underwriters for those policies are certainly going to be exploring what kind of systems and policies you have in place at the time you're buying that insurance.
Excellent. Thank you. Yeah, there was a question about the hospital link that Matt Hafter had mentioned. Could you repeat the name of that, Matt?
Sure. It's called Hospital Cyber Resiliency Initiative Landscape Analysis, and it was released by the Department of Health and Human Services. And I believe it was sometime in mid-April, roughly.
No, that's great. I'm a huge believer in cross-industry. Some industries have guidance, even if it doesn't directly apply in your space, may have a lot of useful things. So if you're in higher education, you're in financial services, you're in some other industry, and there's something that comes out that's from healthcare that's particularly good, have a look at it. There certainly may be things you can learn from it. So with that, I think we will close. Thanks to you and for all of our speakers for participating in the presentation today. Please complete and submit the survey that'll appear at the end of the session. And let us know if there are topics on the cyber space or in the M&A space that you'd like to hear from us on in the future. We certainly listen to that. So thank you for attending, and hope this has been helpful. Thanks.